Nothing herein shall constitute legal advice nor create a solicitor-client relationship. If you are currently facing legal troubles, please seek your own independent legal advice. Many law firms provide a non-obligatory, free of charge first meeting, especially for divorce and criminal matters. All opinions expressed here are our own and do not reflect the values, opinions, and practices of our firms, friends, and families.
Okay, so today's episode is going to be about the recent decision regarding 377A.
Yay!
So G is a particular specialist in this area. He's got a lot of experience with constitutional law issues. So G, go ahead. What is 377A?
377A refers to a section in the Penal Code, the section that talks about criminal law in Singapore. And if I read it out, it says any male person who, in public or private, commits or abets the commission of or procures or attempts to procure the commission of any male person of any act of gross indecency with another male shall be punished with imprisonment for a term that may extend to 2 years. Putting all that legal jargon shortly, it just means if you engage in sexual intimacy with another male, you are punishable by imprisonment up to 2 years.
Okay, so I think before we go into the specific details of the recent judgment, 377A has actually been discussed in many different forums over many years. Would you be able to give us some background as to the history of 377A? How did it come about? Where did we adopt it from? What was the last decision that the court made on this? Because memory serves me right, there was a decision regarding a Tan Eng Hong case. You can maybe tell us the story of that case, and then also we'll move on to discussing why this judgment in particular is so different and so groundbreaking as compared to the other judgments in the past.
Oh, that's a really multi-part question.
Can we start with part one? Give us a background and history of 377A.
We have to go really far back to the 19th century. It starts with what is called the Indian Penal Code. That was essentially the British people came to colonize India, and they set up a comprehensive criminal code that will govern Indian society. Even though before they had come to colonize India, India obviously had its own sets of criminal codes, criminal laws. It was all superseded by the British when they came in. In the Indian Penal Code was what is called Section 377, which is a different section from the current Section 377A. Section 377 is an offence punishable up to 10 years. It is not specific to conduct between males. Instead, what it says is any conduct against the course of nature, any carnal intercourse against the course of nature is an offence. This has been interpreted to give rise to offences, of course, between man-man sexual conduct between women, and also non-procreative, penetrative sexual conduct between heterosexual people, such as anal sex.
I'm just wondering if this extends to like bestiality. Is there a crime against bestiality in Singapore?
There is a separate section.
There's a separate section on bestiality.
Yes.
Holy shit.
Yes.
What?
There's also another one where you cannot have sex with a dead person. Like it's provided for in
Necrophilia.
Oh gosh.
Yeah,
This is very unsafe.
It's all adjacent to the current Section 377A. So essentially, 377A is put adjacent to necrophilia and then bestiality. But coming back, we had 377. So that was, what was it again? Carnal intercourse against the order of nature between people. So various kinds of unnatural sexual acts. That was in the 19th century.
I'm so surprised you didn't come up with a list.
No list. It's
No
just
list.
vague.
Okay.
Then we had 1938, where Section 377A was enacted. The inspiration for Section 377A was what is called a Labouchere Amendment. It was a law that was specifically passed in the UK Parliament. This law criminalizes, as I mentioned earlier, sexual acts of intimacy, specifically between men. It doesn't say anything about female-female sexual intimacy. It doesn't say anything about unnatural acts between heterosexual people. So yeah, 1938. The next date of note, I suppose, would be the 2007 parliamentary debates. In 2007, there was a wide-ranging exercise to reform the whole of Singapore criminal law that led to very broad amendments to the Penal Code in 2008. Preceding that were the parliamentary debates in 2007, where all these amendments were debated. And one of the very contentious points of debate was on 377A. The nominated member of parliament, Siu Kam Hong, presented a petition to parliament calling for section 377A to be repealed. And various ministers and members of parliament spoke for or against the repeal of 377A. Now, what is interesting about these 2007 debates leading up to the reforms in 2008 was that Section 377 was repealed. And if you recall, that would mean the repeal of any law criminalizing sexual acts between females and the repeal of any law criminalizing unnatural sex between men and women, such as anal sex and oral sex. So everything that was deemed to be unnatural by society beforehand, that was no longer criminal by the 2008 legislative amendments, except for 377A. So 377 was repealed, but 377A, which specifically governs sexual conduct between men and men, that was not repealed.
I think one of the more interesting conversations I've heard about 377A is really about its origins, intentions, and motivations behind introducing it into Singapore law. So I think historians have recently dug up paperwork to suggest, and I think this narrative has been rejected by parties, but historians have suggested that the introduction of 377A in Singapore was taken directly from the UK Penal Code, and it was enacted with the specific purpose of actually stemming prostitution in the homosexual circles. And what we mean by that is essentially that colonial masters, like white men, were hiring Chinese men as sex slaves. And so this was a law to protect Chinese men from being subjected to such slavery. I understand that this has been rejected, but it's just a theory. As I mentioned before, I feel as though motivations are very difficult to find on paper. We generally don't write down on paper what our deepest, darkest secrets are. So this is just a best guess from historians. You had some thoughts on the Indian Penal Code.
We were discussing earlier as to how in modern day, we see that the West is the liberal society and Asian values and Asian customs are the conservative ones. But if we actually go back in time, maybe it was the reverse. It seems like Asian cultures was far more liberal and open-minded, but it was the West that was conservative, at least in this regard.
You may be interested to note that many countries which still criminalize homosexual conduct were former British colonies. Also, when people say that Singapore is a conservative society, they often point to East Asian values, yet all of the countries in East Asia have either never criminalized homosexuality or have abolished laws against homosexuality.
Yeah, so I think my sentiment when we discussed this earlier was that it seems ironic that a lot of, even in 2007, when Lee Kuan Yew gave a very public speech, so you can go to some Straits Times, where he felt it was necessary to make a proclamation on what the government's stance on 377A was. He said this one sentence, which is Singapore is essentially a conservative society. And this was the reason why he felt it was necessary to keep 377A in the books at that time. This was about 2007, what G was talking about just now in terms of the parliamentary debates. So I find it quite ironic because India has repealed this 377. Even in England, 377 is no longer part of the Penal Code. I find it quite ironic that we think about this as a Western liberal idea when it doesn't really seem as if it was a Western liberal idea.
It was the opposite.
Of course, all the major countries in East Asia, in fact, all of the countries in East Asia no longer criminalize gay sex. We have China, we have Japan, Taiwan, Korea.
Yeah, in 2022, it's quite difficult to still hold on to this idea about the Singapore exceptionalism. In Singapore, we are conservative, and so because we are conservative, we should continue to have 377A on our books, on our penal code. I actually think, and again, don't quote me on this, I don't have any facts and figures, but I'm of the opinion that a lot of this keeping the 377A is actually been pushed by religious sentiment, not one particular religion but maybe a mishmash of different religious ideologies. And you see that in the people who come up to speak about these issues, a lot of them belong to very strong religious background. And the reason they form these views is because this is what religion tells them is right. So there comes a point in time where we have to question, are we making these decisions because we're conservative, or are we making these decisions because certain big religions say this is so? And I think there needs to be a very conscious divorce because Singapore is a secular society. We do believe in the idea of independence from religion. That's how we've run for many years, and that's how I think it should be. So I think for me, it was a conscious effort to divorce some of these very public advocates of 377A from their religious backgrounds. And I had to consider in my own mind, ask myself questions. Is this a religious standpoint? Is this a logical standpoint? Is this a legal standpoint? How do we differentiate law from religion? So I think those are very, is a food for thought kind of thing. No right answer.
I suppose the interesting point made by Minister Shanmugam in his recent speech in Parliament after the passing of this recent judgment was that attitudes have shifted in some part since 2007, which was when the debates were last held, though the attitudes have not shifted very much. But what they had observed was that people who were against the repeal of 377A, they were not so much gunning for criminalizing of same-sex sexual activity. What they are just more worried about is if we repeal 377A, to them, it will be a very big shake-up to the current structure. Would it lead to a slippery slope where we start to have more social and housing benefits for gay couples? Do we start having gay marriage? Do we start having gay adoption? Or might even lead to worse outcomes such as legalizing bestiality or necrophilia, that sorts of things. So I found it quite interesting that the minister, when he said, actually, this whole debate, the whole polarization that comes from 377A that deals specifically sexual intimacy between men, is not about sexual intimacy between men, but rather it's about worries over general LGBT lifestyle.
Yeah, I mean, one of the biggest things that the LGBT community has been accused of in the past is that of the spread of HIV and AIDS. I mean, even recently in the news, we've had these doctors who were LGBTQ who was essentially falsifying AIDS and test results to ensure that their partner could come to the country and work in the country. So I think there are a few black sheep in the LGBTQ communities who sort of give the community a bad name. I'm not even for a moment saying that this is a rampant thing, but I'm saying that there's a reason why the community at large has certain fears. It is true that in the past, in the US especially, AIDS and HIV was rampant in the gay community. And this is borne out by fact in the US. But this was a long time ago. It's talking about the hippie generation, where sexual liberation was a thing in the West. Right? So there's a question about whether these fears still remain today, where there's so much sexual education, where there are so many clinics that offer STD testing for anybody. So there's a question about whether those fears are still rational fears to have in 2022. What do you think?
Again, while I do not for one moment want to validate any idea about HIV being a gay disease or anything, it is indeed borne by statistics that there are higher rates of transmission of sexually transmitted diseases, not just HIV. Of course, you have issues like syphilis, gonorrhea, and all that, between the community of men who engage in sexual conduct with other men. Conversely, the demographic with the lowest amount of sexual transmissibility happens to be women who engage in sexual contact with other women.
This is an interesting fact. I didn't know that.
Because
maybe we just have less sex.
Yeah, that's the most stereotype.
Less dangerous sex, I suppose.
Lesbians essentially they come together and then they build a nest and then they stay at home. That's the stereotype. But yes, it is statistically borne out by fact. And that shades into a discussion of what are the broader impacts of a law such as 377A. Does it have an impact in terms of outreach efforts by NGOs to members of the community in terms of sexual education? How directly can they speak about same-sex sexual conduct in public in order to educate people about sex education? So one point that we may think about is that 377A may have impacts detrimental to the community far beyond merely symbolically criminalizing same-sex acts.
Okay, I think that's sort of a good context to start this discussion. So I want to go back to the 2007 debates that G was talking about earlier. So a very famous, infamous, controversial character in this whole 377A debate is this professor by the name of Teo Lian. She's been a professor at NUS for many years. I'm not sure if she still is. She is, yes. And she's a very prolific writer in the areas of 377 and a lot of other things. In 2007, she gave a short, passionate speech about why 377A should remain on the books, Penal Code black and white. So she raised four, she called them red flags. So she said a debate must be based on substance and not sound bites. Let me red flag 4 red herrings. I'm going to just briefly tell you what these 4 red flags are, and maybe perhaps you can address the red flags. We all feel that 3778 should be repealed. Of course, for various different reasons, personal and political and, policy-wise. But let's talk about these red flags that Theodiane has raised. So the first red flag she raised is to say a law is archaic is merely chronological snobbery. Soundbite, we'll continue, we'll come back to that. And then she goes on to say, we cannot say a law is regressive unless we first identify our ultimate goal. If we seek to aid the sexual libertine ethos of the Wild Wild West, then repealing Section 3778 is progressive. But that is not our final destination. The onus is on those seeking repeal to prove this will not harm society. So essentially, first is just because it's old doesn't mean we should take it away. Second is, you say you want to take it away, then prove it to me that, society will not be harmed. So based on these 2 conditions first, what are your thoughts?
For the second one, I think that the burden will always be on the person who is saying, okay, don't do this because it is harmful, and not so much on the other person to say that if I do this, it is not harmful to society. So it is weird that she's saying that, if you want the law out of the books, you have to prove that it will not be harmful to society. I think as far as criminal law is concerned, if your law is basically criminalizing someone else's activity, infringing on their rights and telling them that they cannot do this when others can, so the burden will always be on that person to say why, if you do this, it will be harmful to society. So at least for that second argument, it seems weird that the burden is shifted on gay people.
But I think the more practical question is, how do I prove that it's not harmful, right? Because how do you prove a negative, in a sense? If the law doesn't have any impact, then there's no harm. How do I prove there's no harm? How do I prove a negative? That's always a difficult question for me to answer in any kind of litigation. Whenever someone else asks me to prove something that doesn't exist, I'm like, the bank account doesn't exist? How do I prove that the bank account doesn't exist? The money doesn't exist. How do I prove that the money doesn't exist? So on a practical sense, any thoughts on how we can prove that LGBTQ behavior will not bring harm to society?
Yeah, because the issue here is that the harm that is being talked about is not in terms of, I suppose, what we call tangible harm to specified individuals. What is talked about is a very diffused, very broad brush-based harm. Then it no longer becomes a matter of proof or not proving whether society as a whole is harmed in this very broad brush fashion, because I suppose there are some acts which reasonable people will undisputably agree will cause that sort of harm to the entire society. But maybe there are other sorts of harm that will be more contestable, and then it becomes no longer a matter of proof, it really becomes a matter of argument.
Yeah, so actually this leads us into the third. So remember I said that there were 4 red flags that she raised. So we talked about the first 2. So we got to the third one, which is exactly what G is saying. So she says, a law which criminalizes homosexual acts because many find it offensive is merely imposing a prejudice or bias, boldly assumes that no reasonable contrary view exists. This evades debate. The liberal argument which says sodomy is a personal choice, private matter, and victimless crime merely asserts this. It rests precariously on an idiosyncratic notion of harm, but harm can be both physical and intangible. Victims include both immediate parties and third parties. What is done in private can have public repercussions. I think she wanted this to be a short speech, so there are no actual examples that she's given of what public repercussions she's talking about or what the intangible harms are. I do think she has other writings and other pieces on explaining what these intangible harms are. I don't have them at my fingertips, but perhaps you could address this. What do you think about the idea of intangible harms?
I would agree that there are acts that engage public harms, maybe generally. Maybe if you have acts of public indecency, or if you are engaging in sexual conduct in your home in plain view of other people, it may not harm people in the sense that they are victims in a certain sense, but I suppose if you have children seeing these things, we have public seeing these things, it's not, in that sort of sense, it can be.
But we have laws for that, right? I mean, apart from 3778, you want to talk a bit about those?
Yeah, we have laws under the Miscellaneous Offences Act that criminalizes acts of public indecency. We have laws that target sexual grooming of minors. In fact, now there have been numerous amendments made to under Section 377B to G, I believe, of the Penal Code that now targets a lot of these other sexual offences in greater detail. But I suppose that if I want to look at her point of view, these are the kinds of offences that she says you're not harming somebody directly, but it results in broader harm to society. And she's just saying, as a matter of categorization, 377A acts fall into that category.
I agree with her. I mean, in the sense that it is possible for acts to be done in private, which can be harmful to society. So just on that point, it is possible. I won't disagree. But the question is really, as far as 377A is concerned, what is that harm to society? Usually the argument that I've heard quite often is that the fabric of society, what a family means in society, in the Singapore context, is between a heterosexual male and a heterosexual female. And so anything that goes outside this general rule, outside this convention, it would affect the social fabric. And I think that is the harm that she's referring to. As to whether that is really true, I'm not sure. I mean, sometimes I just imagine if, let's say, we do repeal 377A, maybe we don't go down the slippery slope. I'm sure Parliament can always decide if Singapore is ready for gay marriage, so that's fine. But if we take out 377A, apart from the slippery slope argument that there might be other rights and liberties that are given for gay people, I'm just wondering, what exactly is this harm that they are talking about? So if we have sufficient safeguards, any idea what this harm is? If let's say, okay, no gay marriage, we're not going down that slippery slope.
Well, I think this requires us to make certain assumptions. But many people believe that homosexuality is an imprint on your DNA, meaning that it's something you are born with and not something that you essentially choose as a lifestyle or you're influenced by your parents or relatives and things like that. But there's no concrete science to prove this. But there is some scientific research to suggest this. So we're at a stage where we're not very sure where we lie in terms of science. And even if we had scientific study to prove one way or the other, there's always this idea of we don't know what we don't know. There may be a scientific study in 20 years to come up and say this study is wrong. I mean, I'll give you an example. In my time, Pluto was a planet. Now it's no longer a planet. So let's keep that in mind for context. But coming back to this idea of what's going to happen, it almost seems as if a lot of assumption is made about the transferability of gayness. Just because you're friends with a gay person, are you going to be gay?
I wonder how many people really believe that. Maybe there are people in Singapore.
No, but I think that's the inherent assumption. Because when we talk about the erosion of morality, if we were to make an assumption that being gay is immoral, and that would be subsequently an erosion of morality, that means that gayness would implode. So what they're worried about is a society where more and more people become gay and accept this as immoral, as an immoral.
Right, yeah, who would subscribe to this, right? Who would say that, okay, now that I can have gay sex, I want to have gay sex, even though I'm a straight person.
I suppose the comeback to that would be that all LGBT communities, they are all bombarded with positive portrayals of heterosexual, neutral family unit. And in fact, a lot of them, most of them want to be in such units. Most of them want to engage in fulfilling and enjoyable relationships with members of the opposite sex. And they actively try to, but they can't. And so if you assume that gayness can be transferred in some sense, then you should also say that straightness can be transferred in some sense. How come it's not happening?
The success rate of conversion courses.
There was an argument raised once that I thought was very compelling, and it's that, look, the LGBT community suffer so much in terms of discrimination in normal life, right? They suffer so much in terms of their psychological well-being because it's something that they've had to hide. It's a burden they've had to keep behind closed doors. They can't have open relationships. They can't be in marriages. They can't adopt children. They can't even get a child through surrogacy in Singapore. As an LGBTQ member, you are faced with so much trauma. Why would you actively choose such a traumatic life if you had an easier option? Exactly. I thought that was a very compelling argument. Why would you choose the road that's more difficult to live if there was any other choice? Okay, so we've talked about the first three red flags. I'm going to go with the last red flag, the fourth one, which I think is most debate-worthy. So she says, fourth, legislators are urged to be open-minded and decriminalize sodomy. However, like an open mouth, an open mind must eventually close on something solid. Legislators are urged to be objective and leave their personal subjective beliefs at home, especially if they hold religious views that homosexuality is abhorrent. This demand for objectivity is intellectually disingenuous, as there is no neutral ground, no Switzerland of ambivalence, when we consider the moral issues related to Section 377A, which require moral judgment of what is right and wrong. Not to take a stand is to take a stand. As all law has a moral basis, we must consider which morality to legislate. Neither the majority or minority is always right, but there are fundamental values beyond fashion and politics which serve the common good. Religious views are part of our common morality. We separate religion from politics, but not religion from public policy. That would be undemocratic. All citizens may propose views in public debate, whether influenced by religion or secular convictions or both. Only the government can impose a view by law. What are your thoughts? I think essentially what she's trying to say is that we can't ignore religious perspectives because religion is part of our society. And so we need to accept religious perspectives because that is what being in a democratic society means.
Especially if it has to do with this kind of issues which touches on moral principles. Can't divorce religion completely. I guess that's what she's saying. I'm really not sure about this because this goes against the whole notion as to what living in a secular state means, right? So even if you, let's say, the predominant religion in Singapore requires people who follow that religion to only eat a certain type of food, and that issue arises as to whether or not eating that kind of food is permissible. If lawmakers, parliamentarians were to vote just based on that, then it's no longer living in a secular society, right? Because there are so many aspects of life. That's religion. It pervades into so many aspects of a person's life. If you put aside your secular beliefs and you always vote or pass bills based on what that religion requires of you, then you are in fact creating a society which is no longer secular but just based on religious principles. So I'm not sure how far Teo Lian will go in terms of this argument. I mean, in terms of 377A, she stated her views, but what about other kind of things? Is it okay for parliamentarians to just vote based on their religious beliefs and then take it that's perfectly all right?
One concrete example may be how the Catholic Church says that abortion is immoral categorically, even if you undergo an abortion procedure where you have been raped. So my understanding, at least, of course I can be corrected, is that even in an extreme situation such as where you've been raped, abortion is still immoral categorically. And many countries who are Roman Catholic actually, in fact, follow that position. So I suppose following up from T, what is the logical extent? If all that she's saying is that religious perspectives should be allowed to be considered when it comes to public policy and decision making, then yes, we have perfectly no issue. But I suppose when it comes to issues like what to criminalize, because when you have criminalizing something, it's very concrete. I do criminal law. Day in and day out, we have cases where people come in and people are like crying and they're like, today, I just happened to accidentally turn my car in a certain way and then it crashed into something and nobody was injured and nobody was, it's just a bit dangerous and people's lives were in danger, but nobody was injured and you mean I have to go into jail for 3 months for this? When you see these kinds of very concrete applications of the criminal law, how it actually affects people's personal liberty, how being subject to a criminal charge really affects somebody's life, would you be that confident in saying, let's just have a law there as a symbol to say it criminalizes you, you are criminal, but don't worry, we are not going to prosecute you and you're not going to come in. I think when she talks about religion being part of the equation, when it comes to public policy decision making, she should also need to consider some of the concrete examples of how consequences of how taken to the logical extent, what are some of the really concrete injuries to specific groups of people that can result in.
So I guess what you're saying is she takes a macro perspective, but she doesn't really consider how this would impact the individual, right? And I guess that's what it is.
Yeah.
Yeah. Okay. So I think this is a good segue. So we've talked about, what the arguments raised in the 2007 parliamentary debates were about. There was a case around the same time or immediately after this decision wherein the Supreme Court gave a decision on 377A. So this case is known as the Tan Eng Hong case. It was decided with some other cases, I think, all at once in the Supreme Court. G, I know you sort of helped out in this case. Maybe you want to give us a background on what happened in that case and what the court said in that case?
That was a constitutional challenge that started in 2010. It culminated in a decision by the Court of Appeal in 2014. It was brought by, I would say, two applicants. One is, as you correctly mentioned, Tan Eng Hong. The other is called Lim Meng Suang. So actually, the decision is more well known as the Lim Meng Suang decision. In that case, the applicants challenged the constitutionality of Section 377. To explain what that means, it is to say that Section 377A is contrary to Singapore's Constitution, and because Section 377A is contrary to the Singapore Constitution, the court has a duty to strike down the legislation as being void. So the issue with such cases, when things get brought before the courts, is that many of the complicated points that we were discussing earlier, these issues of morality, issues of religion, the merits of the substance and merits, and how correct each party's views on these matters are not really what we say relevant for the court, because supposedly what the court looks at is only legally relevant things. So how do we park this debate into a legally relevant? Well, in the Lim Meng Suang case, the applicants say that that law is contrary to at least three sections of the Constitution. So first is Article 12. Article 12 of the Constitution says that all laws passed by the Singapore legislature must respect the concept of equality before the law, and that all must be equal before the law, meaning that there should be no unlawful and irrational discrimination between different groups of people. So that is Article 12. We have Article 14, which talks about freedom of expression, and we have Article 9. Article 9 says that you can't be deprived of your personal liberty, meaning you can't be imprisoned except in accordance with law. But the courts have said that law is interpreted that narrowly. It doesn't mean any law passed by Parliament. It also refers to what they call fundamental rules of natural justice, and also that law cannot be absurd and irrational. So the challenges were brought under Articles 9, 12 and 14. It went up to decision in 2014, and the Court of Appeal dismissed all of it and said, no, it's not contrary to any of these laws. And insofar as you are trying to mention the various debates that we were just talking about earlier in this episode, those are all legally irrelevant, and the court doesn't look into it because the court is not Parliament. The court only looks at legal arguments.
Yeah, that sort of summarizes the entirety of the 377A debate from inception until 2014. So the most recent decision that was released, I think, 2 weeks ago from the date that we're recording this. How does this decision differ from previous decisions, and what was the significant impact, if any, of this decision on society at large?
I suppose to answer that, we should have some background on how the current challenges were brought in or around September 2018. We had a seminal decision of the Supreme Court of India, where the Indian Supreme Court ruled that Section 377, because they hadn't repealed their Section 377, Section 377 was contrary to the Indian Constitution. Subsequent to that, the three applicants in the current constitutional challenge brought a renewed application in the Singapore courts to say that it's all unconstitutional. One of the reasons given was that at the time 2014 was decided, we hadn't had a decision of a major Asian jurisdiction such as India saying that it was unconstitutional. So now things have changed. Other grounds were also that the Court of Appeal's previous decision in 2014, when it considered all the legal arguments, were wrong. Because essentially in Singapore's system, the Court of Appeal is allowed to change its mind. It's allowed to say that, its previous decisions were wrong and it should overrule itself. So the three applicants brought their constitutional challenges. And then an interesting thing happened, which was that sometime in the end of 2018, I believe it was October 2018, the Attorney General, in his capacity as Singapore's public prosecutor, issued a public statement. The public statement made reference to the 2007 parliamentary debates, where in the 2007 parliamentary debates, the Prime Minister had explained that government and Parliament would retain 377A, will not repeal 377A, but the government will adopt a policy of what they call non-proactive enforcement, which is to say that generally they are not going to prosecute adult consensual acts done in private under Section 377A. So what Attorney General in capacity as public prosecutor did was to echo the sentiments of the Prime Minister made in the parliamentary sitting, and to say, yes, now I, in my capacity as public prosecutor, I do confirm that my general prosecutorial policy is that, generally speaking, when it comes to consensual private acts between adults, we will not prosecute. So that came out in 2018 after the constitutional challenges started. And the Court of Appeal recently in this 2022 decision actually referenced heavily to that 2018 public statement and said that that was a material and important change in the legal landscape, and that affected the results of this case, which made it different from the 2014 case.
What struck me was the tone in which the judgment was written. Judgments are usually written in a very emotionless manner where it's just facts, my decision, facts, my decision, facts, my decision. And that was also the way in which the 2014 Lee Meng-Shuang decision was written. It was very facts-based, very almost dismissive. The tone in which it was written, it was like, all these are not relevant, full stop. But what struck me as different in this decision was the way the courts had used the word kin to describe our LGBT brothers and sisters, how they sought to almost characterize the LGBT community as an important part of the community that we should consider. It almost seemed as if they wrote the judgment with the acceptance that the LGBTQ community are Singaporeans. We should recognize them as a part of society. Even though it's not explicitly written, but the tone of which it was written differs greatly from past decisions and the decisions generally that courts publish.
What I found interesting, for example, was that they made reference to Obergefell. Obergefell is the US Supreme Court decision which said that gay marriage was now a constitutional right in the US. They talked about how Section 377A is a criminal law that touches on one of the most private and intimate conduct that you do in closed doors. And they're saying that 377A is not just about criminalizing, it's about many more of such things. What I also found interesting was a reference they made to Roe v. Wade. Roe v. Wade is the 1970s US Supreme Court decision, which essentially said that the right to choose an abortion is part of a woman's constitutional right to privacy in the context of the US Constitution, and that therefore laws that unduly burden a woman's right to an abortion will be struck down as unconstitutional. So what Court of Appeal here have said is they have referenced what has happened after Roe v. Wade in the US. So apparently, before Roe v. Wade happened in the 1970s, the states in the US had been going on a trend towards liberalizing of abortion laws. There were people who were recognizing that, yes, abortion should be recognized for medical reasons or even for reasons of the woman's personal autonomy and choice. The legislatures were having debate about that. And in fact, the states in the US were moving in the direction of Roe v. Wade, which is of decriminalizing abortion. But then what happened is we had this Supreme Court decision in the 1970s that came in and said, no debate, because now your right to an abortion is a constitutional right. And therefore, you, the legislature, you are not allowed to unduly burden this right. And what some scholars who actually support a right to abortion have said, regrettably, about the decision in Roe v. Wade is that it actually closed the debate, but in doing that, it generated a blowback in the sense that over the next few decades, you have a very strong conservative pushback against abortion, which resulted in a lot of people appointing judges based on whether they believe that Roe v. Wade is correct or not. And now, very recently, the US Supreme Court is, in fact, considering whether possibly to either water down or even overrule Roe v. Wade altogether, and that could very well roll back many, many decades of abortion rights movement. So
I'm sorry, I'm going to cut you off here just for a moment to bring again some context to this discussion, because in the US, judges are not appointed per se, they are voted in, and you know, like the ADAs and the prosecutors there, they are voted in by popular vote. And a lot of these Supreme Court judges, they are chosen by the political party that is currently in power. So when Trump was in power, they brought in that conservative judge, Supreme Court judge, that sort of tilted the balance more conservative than liberal, which is the reason why Roe v. Wade is being re-examined again, because of the difference in the mindsets of the judges. But that process doesn't exist in Singapore.
Yes, indeed.
Yeah, I just wanted to put that out there.
Yes, the process of appointing judges or electing judges in the US is indeed much more political than Singapore. I suppose the message the Court of Appeal was sending here, which is saying that, you, the homosexual community, may not entirely be in your own interest for us as the court to be finding in your favor by finding a constitutional right, because look at what happened in Roe v. Wade. Perhaps that's not really the fairest of comparison, because we have a much less political, or we don't have a political judiciary in Singapore. But yes, I suppose there was a very long talk about your observation about the tone. It's a more respectful tone.
Yeah.
It seemed to be trying to explain its decision more. It seems to be targeted more towards the LGBT community and saying, I understand that you may be very disappointed about facial outcome of this case, but look at things in a more broader perspective, look at things in context, and we are trying our best.
This seems to be an olive branch to me. It very much strikes me as a mending of fences and building of bridges, as opposed to a purely dismissive tone that I think the court took in 2014. We've talked a lot about the tone, but let's really talk about the decision. What did the court decide this time around?
So the interesting thing is the court decided not to decide many things. So the applicants here argued that Lim Meng Suang was completely wrongly decided, wasn't it? So again, they re-argued points on Article 9, that you can't be deprived of life, safe in accordance with law. They talked again about Article 12, which is equality before the law. They talked about Article 14 again, which is freedom of speech. The court said, okay, these are all very interesting arguments, but I'm not going to come into a conclusion on all of these points of constitutional law, because I'm going to make a ruling that makes it unnecessary for me to decide these constitutional points, and that is what they call substantive legitimate expectations. What is substantive legitimate expectations? What that means is that because the public prosecutor had made certain public statements in 2018, which I've spoken about earlier, where he said, my general policy is I will not prosecute normally in cases of adult consensual acts done in private. This 2018 statement is consistent with what the court called the political compromise, the political package struck in 2007. And given that the public prosecutor have said that this was their general policy, the LGBT community have come to rely on that statement in organizing their affairs, in the sense that they're thinking, well, I'm not going to generally get prosecuted if I engage in such acts, so therefore I suppose I'll continue engaging in such acts. That, according to the court, gave rise very exceptionally to a substantive legitimate expectation, meaning to say it is now unlawful for the prosecutor to charge anybody under Section 377A.
Yep.
Subject to certain conditions, of course. Yes.
But I guess the real question I have, and it's a question I posed to you earlier when we were discussing this episode, is what does that mean in practical life as a member of the LGBT community?
What it practically meant was that before this decision, if you were charged with 377A, even though the government had said that they won't do so, if you were charged under Section 377 and you did indeed commit adult consensual acts in private, you are technically guilty of a crime and you will be subject to either a fine or imprisonment, full stop. What this Court of Appeal decision has done is to change that position. So now, if you committed exactly the same acts that you committed before this decision, if you are charged with Section 377A, you can, in fact, bring an application against the Attorney General to say that the Attorney General's prosecution is unlawful, and the High Court will say, yes, that decision to prosecute is unlawful, and quash the decision. So quashing means the court will say unlawful, don't prosecute under 377A. So that a political promise made earlier has now turned into a legal, legally enforceable undertaking.
Okay, that's great. But I guess this is still a disappointment for majority of the LGBTQ community. Maybe you want to address where the disappointment lies and what we see moving forward in terms of the political and legal landscape in terms of 377A.
I suppose the disappointment, first, if I may deal with the legal merits of the case itself, then perhaps I deal with the more broader implications. In terms of the legal merits of the case, one of the arguments run, as I mentioned, was that the law is in breach of Article 12, which is in breach of the concept of equality before the law. One of the grounds put forward is that this law is inherently and manifestly and irrationally discriminatory because it criminalizes only men and not women. Not to say that women should be criminalized also, but the fact that only men are criminalized just shows how irrational and how without legal reason it is. Other than Article 12, the applicants put forward other arguments. But the fascinating thing is that while the Court of Appeal here, and remember this in the context of what I said earlier, which is that the Court of Appeal had said, I'm not going to answer all these constitutional questions, but they still went ahead and answered it at the same time. They answered it while saying, okay, whatever answers we give to these constitutional questions has no legal consequence because our ultimate answer is substantive legitimate expectations. Okay, but they went ahead and answered. They said no to Article 9. They said no to Article 14. But when it comes to Article 12, equality before the law, the Court of Appeal in this current case, they didn't go and say, had we been needed to decide Article 12, we would have decided Article 12 the way Lim Meng Suang was decided. They just kept completely silent, which in the minds of LGBT community, they feel disappointed because they feel that if the Court of Appeal hadn't ruled on substantive legitimate expectations, there may have been a higher probability that the Court of Appeal may actually strike down 377A as being contrary to Article 12. And if the Court of Appeal had done that, it would have sounded a very strong, I suppose, signal to say this law is truly irrationally discriminatory, it is truly unconstitutional, and really, Parliament, you shouldn't be having these laws in the books. So they are disappointed in that sense.
Yeah, but we know that's never going to happen, right? At least not in the next few years or in the near future. I find that is a very big leap from all the positions that the court has taken in the past to one day come out and say, oh, all our past decisions are wrong and you are right now, we're going to change the law. I think that that's a very difficult decision for any court to take, not just in relation to this one issue, but to any issue. They're not just going to say 3 decades worth of legal decisions is just out the window today. I think it needs to be something that is really compelling, something that really is going to change people's lives and the fabric of society, as he says. But I think that's a very good discussion on what the current decision is. I would just like to end off with Shanmugam's statement made to Parliament on this issue. Maybe you want to give us a soundbite on what Shanmugam said and what we can expect in future.
Shanmugam said that government is looking actively into this issue. He seems to be signaling that there may be some change. I think he did signal also that if there's any change, it must be carefully managed. He also gave, as I mentioned earlier, some observations regarding how society is viewing this issue. He said that there were some shifts that they had observed since 2007 till now. Not very significant, but indeed there were shifts. And he said that, again, generally when people are against repealing 377A, they are not against the concept of decriminalizing homosexual acts specifically. What they're more worried about is supposed slippery slope.
Which is essentially, can homosexuals or LGBTQ people get married and have children and have a right to family and all that other stuff, right? That's what we're talking about.
Indeed.
Okay, so essentially, even moving forward, if we were to take Shanmugam's comments at face value with nothing else, because we have nothing else, all we have is his comments, right? So if we were to take his comments at face value and assuming that there would be a change in relation to 377A, that would not mean that the government is also thinking about things like marriages between men and women and women, or that the law would change to allow men and women couples to adopt or have children via surrogacy. That's not what he's saying at all, right?
Yes, that appears to be so.
So it's still, in fact, a long way away for the LGBTQ community to get any sort of light at the end of the tunnel.
Yes. So, for example, in the Women's Charter, marriage is defined as between men and women. So, for you to have any change in that direction, you needed a specific Parliament amendment to say, now marriage is no longer between men and women.
And independent of our personal feelings, we don't think this is going to happen, right?
Not in the near future.
Yeah, this is not going to happen.
Absent a very significant change in public attitudes.
I think that's okay. Parliament should be careful when allowing for marriage norms to change. Yeah, I don't think it's something that that they should rush into. 377A, I think it's high time that they get rid of it because it's a criminal law, right? The consequences are that if you are arrested and charged, you might potentially be sentenced to a term of imprisonment. And that's, of course, if the AG of the day, the Attorney General of the day decides that, okay, yeah, this law is enforceable. But I think when it comes to marriage and all of that, I can understand why it would be such a dramatic change for men and men to get married and for men and men to have children, or women and women to get married and women and women. So it's something that I can sympathize.
Yeah.
Yeah.
So I think the general conclusion we can come to at the end of this discussion is that we do see some building of bridges and mending of past hurts when it comes to the LGBTQ community. But that's not going any further. We don't see an actual right for LGBTQ members to get married or have children in the future. That's really off the table. So I think we all agree with that, right?
Agree that I suppose this is the likely direction that it's going on. Of course, whether we agree with the policy making.
Of course. Whether we agree or not is, like I said, this is aside from our own personal feelings. This is just what we see the legal trend is going to be in the next 5 years at least.
Yes.
Okay, so I think that's a good close to this discussion. So it's bye from me.
Bye-bye.
Bye.
See you next time.
What we discuss in this podcast is general information only and is not legal advice. Also, our discussion does not give rise to a solicitor-client relationship between us and you, our listeners. If you are currently facing any issue or problem, you must obtain your own independent legal advice. Some law firms provide a non-obligatory, free of charge first meeting, especially for divorce and criminal matters. All opinions expressed here are our own. They do not reflect the values, opinions, and practices of our firms, friends, and families.